Court does call the case. The People versus right on the annual. Is it Burnt House?
Your Honor, the D is silent. Stephanie Cannon on behalf of the Sprint House. Sorry, did you want to do that? You're okay.
No, she did not. You're so rude. Go ahead, Mr.
And I'll have to be clear.
Please state your name for the record.
Daniel Barnhouse.
Thank you. Shannon, this is your motion.
It is my motion, Your Honor.
Go ahead.
Your Honor, my client, this is a motion to amend the bond condition to allow him to live in Ohio with his brother. There are no minor children present. My client was able to bond out. He paid a substantial bond of $50,000 cash. Based on the allegations in this case, he cannot return home as the complaining witness lives there. Outside of that household, he has no family. He has no other people here. It's that all of his family lives in Ohio. My client, when he was released, he was told he couldn't go to Ohio. He immediately called me. We set it up so that he had provisions here. However, he is not a rich man. He can't continue to pay hotel costs and motel costs. He simply wants to be allowed to go to live with his brother in Ohio. He will come back for court when required. He is here today. He is not a flight risk. The $50,000, his family is not rich. So that $50,000, if he were to abscond, would be a major loss for his family who put up the monies for that bond, Your Honor. My client is just simply asking not to be made homeless, and because he has nowhere to go. He just doesn't have anything else outside of his family. So he's just simply asking to be able to reside in Ohio, and he'll come to court when the court asks. He's here today. He'll be here whenever the court requires him to be here.
Sponsoring the People.
Your Honor, ultimately, I'm going to leave it to the court's discretion. I do want to say a few things. I don't feel this is an emergency situation. I understand that that's the perspective of defense and defendant. However, defendant being unable to return to a residence where he sexually assaulted his own daughter, quite frankly, is not an emergency. With that said, like I said, I'm going to leave the court's discretion. I am concerned that he's out. I am concerned, especially given that there has been statements made by the victim and the mother of the victim that they are in great fear of this defendant. Also knowing that when police went to interview him, he asked if he could go back into the residence to grab something. They escorted him into that residence and found that there was a gun sitting out on the couch. So what he was going to do or not, we don't know. Luckily, nothing happened. But there are a lot of concerns. I understand that $50,000 is a high bond. Obviously, he's posted it and we are where we are. I do have great concerns. We're in a tough situation because on the one hand, the further away he is, the better. On the other hand, I'm not sure what will happen if he decides to take off. I'll essentially just leave it to the court's wisdom and experience in handling these things. I just want to put those concerns on the record. If he's allowed to go to Ohio, I'd ask for home confinement. I want to make sure we are also have bond conditions in place for no contact with any minor children. I would like to also know that the residence in Ohio is nowhere near school or daycares or anything like that. So for me, quite frankly, it's a little premature. Again, I don't see it being an emergency in that sense. I think that certainly need some more information. If that can be provided, I'd happily look at it. Those are some of my concerns.
Thank you. Your Honor, as far as the weapon in his house, at that point, he was lawfully owning the weapon. It was his house, having a gun in the house. I don't know how that reflects on whether or not he will return to court or abscond from the court in any way, shape, or form. My client is simply asking not to be made homeless. The brothers in question are present. They are here. They live without children in the home. He has no problem not being around children. And
what major city is Plymouth, Ohio near?
I'm sorry, what is what?
Well, what major city is?
Mansfield is
Mansfield is it?
Mansfield, Ohio, yes, Your Honor.
Okay. And you're currently on a tether?
No, sir.
No, Your Honor, it was 50,000 cash. You didn't put a tether provision in. It was, he just stayed.
I didn't. You mean the court
The
did?
court did not, Your Honor. And again, he's here, so he's been out. He's not trying to abscond. He wants to handle this case the right way.
Are there schools located in the area? Right around that?
No, not close to where they live at, no.
When you say not close to, what's that mean?
We're probably about a mile away.
That's
On the
close.
other side.
And Your Honor, yes, our people position is that is too close. We'd also like to have an exact address so we can confirm that. I understand that's coming from defendant's brother.
It's actually in the motion. I was just putting it on the record.
Your Honor, I mean, even if he were to stay here, no matter where he's at, he's going to be within a couple of miles.
Did you catch that? The judge just discovered something he wasn't expecting. The defendant wasn't being electronically monitored at all. That changes everything. Sometimes a single overlooked detail completely reshapes a hearing. Now the court isn't just deciding where the defendant can live. It's figuring out how to make sure he stays accountable while awaiting trial.
If he were in his home, he's going to.
Right. But so first of all, I've got a number of different problems. One is he posted, there's no tether. Okay. So I'm starting from a whole different position than where I thought I might be starting. He's not tethered, but in order for him certainly to go to Ohio, well, irrespective of whether he goes to Ohio, he's going to be on a tether. He's got to report to community corrections for a tether.
Your Honor, when I attempted to stipulate to this, not with sister counsel, but with another attorney, I said he will even tether to the house. He had no problem with that.
Tether to which house?
To be on his brother's house is the only house he can go to. So that was indicated.
No, I'm not saying that there's anything bad about it. I'm just saying he's going to get a tether. The question becomes then, and what's he planning on doing while he's there? Is he going to be working, or is it just that he needs to be around family at that point?
Well, Your Honor, he is a disabled vet with PTSD, anxiety, and various things. So usually his family would actually come stay with him. So they would drive up from Ohio and actually stay with him. So no, because of his disability and everything, he is not working right now.
Okay. So here's what I need. So what I'm going to order is a home confinement tether. Okay.
Okay.
I will. So he has to be tethered prior to leaving the state. I will let him reside in Ohio at that address. I will also indicate, if they're indicating that it's a mile away, I do think that's too close, but I don't know where else. I mean, in certain respects, you're right that he's going to be near a school regardless, but that's one of the reasons I think home confinement is even more important in terms of that. Since he's not employed, he's only to leave to come up for court appearances here. All right. Otherwise, he is not to leave his home. And
Your Honor, my client is fine with that.
And so in the way I'm going to word it at this point, I'm going to take a look, Google's look, and I may change it in some other way, but right now you're not to appear within 2,000 feet of any school or educational institution. You understand that, sir?
Yes, Your Honor.
And my understanding is that there are no children at that
That's correct, Your Honor. There are no children. It is the brother in blue who lives there.
Gotcha. Okay. There already is a provision I think, and I'm just going to now have to double check this. I actually don't have that provision. But somebody's going to have a long conversation. I'm going to indicate there is to be no contact with any individual under the age of 18. You understand that, sir?
Yes, Your Honor.
We have the two individuals of no contact. I have minor school, mother's place of work, libraries. They already have actually a provision that can't go to libraries, schools, or any place where minor children may be present. I do have that, but I don't have the specific. All right. So that's what we will do. So you need to report before you leave the state. You have to be on that tether. It has to be a home confinement tether. They'll make sure that you have the opportunity to get down to that location.
Today, sir.
You're not going to be able to do it today because it's going to be too late.
First thing in the morning?
It has to be first thing in the morning.
No problem.
All right. And then I think the address is in the motion so that the people have what address he's supposed to be tethered to.
It is, Your Honor.
And
But if needed, I'll email it again. If needed, I'll send it.
Okay. And I'll just make sure my order contains that particular address.
Thank you so much, Your Honor.
Thank you.
All right.
So what do you think? Did the judge strike the right balance between protecting the community and preserving the defendant's rights? Or should the request to move out of state have been denied altogether? Let us know in the comments, because these courtroom decisions rarely have easy answers, and every viewer seems to see them differently.